हाय गाइस, वेलकम बैक टू द यूट्यूब चैनल ऑफ लीगल एज आफ्टर कॉलेज। मैं हूं मानसी और आपके CUET पीजी एग्जाम की डेट जो अब आ चुकी है और इतना नज़दीक आ चुका है आपका CUET पीजी एंड IIT खड़गपुर LLM एंट्रेंस एग्जाम्स बोथ योर एग्जाम्स आर वेरी नियर नाउ। IIT खड़गपुर का जो आपका LLM एंट्रेंस एग्जाम है वो 17 मार्च को है और CUET पीजी का जो आपका LLM एंट्रेंस एग्जाम है वो 20 मार्च को है। तो उसी से रिलेटेड हमने सोचा कि कुछ क्विक क्वेश्चंस करवाते हैं आपको, जिससे आपका एक क्विक रिवीजन हो जाए सब्जेक्ट्स का। तो उसी से रिलेटेड आज हम इंडियन एविडेंस एक्ट के कुछ क्वेश्चंस करेंगे, सिर्फ एक क्विक रिवीजन के लिए। शायद इसमें से कोई क्वेश्चन आपके एग्जाम में आ जाए, हु नोज। So let's start. Please share this video with people who are giving IIT KGP ka exam, also with people who are giving CUET PG ka exam, and with others also who have read Indian Evidence Act, who are interested in reading it, who are interested in solving its questions. So share it, like this video, and subscribe to the channel if you are new over here. So today we'll start with most important questions of Indian Evidence Act. कुछ questions करेंगे, थोड़ा सा एक idea लेंगे. The first question is the object of Indian Evidence Act 1872 as set out in the preamble of the act is what? A. To define and amend the law of evidence. B. To consolidate and amend the law of evidence. C. To highlight, define, and consolidate the law of evidence. D. To highlight, consolidate, define, and amend the law of evidence. So where do we find the preamble of Indian Evidence Act? As soon as आप Indian Evidence Act को open करेंगे, on the first page itself, just below the title of the act, you will find the preamble of the act. And the preamble of the act says to consolidate, define, and amend the law of evidence. So your answer here is option number B. Tick. Right. Moving ahead to the second question. The Indian Evidence Act does not apply to what? A, there are four options out of which we have to select. First is what? Proceedings before the arbitrator. Second, affidavits submitted by the deponent of his own. Third, statements made by a child. Four, statements by a person whose past is criminal. So, Indian Evidence Act does not apply on, first, it does not apply on proceedings before the arbitrator, and it does not apply on affidavits submitted by the deponent on his own. So your answer here will be 1 and 2, which is option number C, right? And where will you find this answer? So this is your section number 1 of Indian Evidence Act, which talks about applicability of the act and accurately provides that it is not applicable to proceedings which are in front of court martials under Army Act, Navy Act, and Air Force Act. It is not applicable to affidavits, and it is not applicable to proceedings before arbitrators. Right? Moving ahead. See, section number 1 of the Indian Evidence Act. ठीक है. Question number 3. According to the interpretation of section 3, fact means and includes what? A. Anything, state of things, or relation of things, or capable of being perceived by the senses. B. Any mental condition of which any person is conscious. C. Both A and B. D. None of the above. So section number 3, which is the interpretation clause of the Indian Evidence Act, defines fact also, and according to it, C will be your answer. It includes anything, state of things, relation of things, and things capable of being perceived by the senses. It also includes any mental condition of which a person is conscious. So your answer here will be C. Right. Question number 4. Which of the following statements is or are correct? Evidences under the Evidence Act means and includes. क्या क्या include होता है evidence की definition में under Evidence Act? ये भी आपको section number 3 जो आपका interpretation clause है उसमें ही देखने के लिए मिलेगा. First, oral evidence. Second, all documents except electronic records. 3, all documents including electronic records. So both oral evidence and documentary evidences fall within the definition of evidence under Indian Evidence Act, and they include electronic records. So your answer here will be 1 and 3, which is your option number D. Option number D will be your correct answer for this question. Moving ahead. Which of the following statements is correct? A. Admission may be oral or documentary or contained in electronic form. B. Admission is by documentary proof only. C. Admissions are the conclusive proof of the matters admitted. D, admission includes admission by conduct. So here another question can be asked कि admission की definition कहाँ दी हुई है? Where is admission defined under Indian Evidence Act? So admission की definition, for giving answer to this question you need to know the definition of admission, और वो definition admission की provided है आपकी section number 17 of Indian Evidence Act, according to which option A is the correct answer. Admission can be oral, documentary, or it can be contained in an electronic form. Right. Moving ahead. Question number 6. Which of the following statements is not correct? A. A confession which is procured by promise is relevant. B. A confession made by an accused to a police officer, whether during custody or out of custody, is irrelevant. C. A confession made by an accused voluntarily to any person other than a police officer while he was not in the police custody can be proved. D. A confession made by an accused to a police officer in the presence of a magistrate is relevant. So here for each of these options you should know section numbers कि कौन से section से हमने इन options को derive किया है. So a confession which is procured by promise is relevant. ये कहाँ से मिल रहा है? This we derive from section number 28 and this is correct. After a confession, no, not 28, section number 29. Section number 29. A confession which is made under a promise of secrecy or a confession which is made with under intoxication, all of such kind of confessions are relevant under section number 29. Section B option क्या है? A confession made by an accused to a police officer during custody. During custody is what? Confession made to a police officer in his custody. ये कौन से section में मिलता है? This we find in section number 26. ठीक है, but do we find an out of custody option? Is there any section which talks about confession made to a police officer out of his custody? No, right? That is why this is not correct. This is not correct. A confession may be made to a police officer out of his custody. That is not covered under Indian Evidence Act. ठीक है. Option number C, a confession made by an accused voluntarily to any person other than a police officer while he was not in police custody can be proved. ये तो आपका general confession है. A confession made to any person. This is a extrajudicial confession and this can be proved. D is a confession made by an accused to a police officer in the presence of a magistrate. This is also provided in section number 26. ठीक. So your answer which is not correct is B because it talks about a confession made made to a police officer without his custody or outside his custody, out of his custody. ठीक है? ठीक है. Right. Question number 7. Which among the following is not relevant under the Indian Evidence Act? A. Previous judgment to bar a previous suit. B. Previous judgment to prove to bar of a second suit, of a second trial. C is judgment in rem relating to matters of public nature. D is judgment in personam against another person. तो क्या है इसमें से जो कि Indian Evidence Act में covered नहीं है? Previous judgment to bar a previous suit. This is covered under section number 40. Under section number 40, right? Previous judgment to prove bar of second trial. ये भी आपका सेक्शन 40 के अंदर ही कवर हो जाता है. Judgment in rem relating to matters of a public nature. This is section number 42. But judgment in personam against another person, this is not covered anywhere at all. So this is your answer over here. This is not covered under Indian Evidence Act. यहाँ पर section number 41 जो आपका है, it talks about probate, admiralty, etc. jurisdiction, which are also judgments in rem, which bar subsequent trial or which bar a second trial. ठीक. So section number 40 to 43 of Indian Evidence Act bar certain kind of trials, and that does not include judgment which is in personam in nature. All right, let's move ahead with our next question. Right. Question number 8. The rigor of conclusive presumption of legitimacy under section 112 of Indian Evidence Act can only be rebutted by A. DNA testing about paternity, B. Non-access to the parties, C. The fact that wife was observing menstrual period, D. The fact that wife has undergone pubectomy recently. So what we need to prove if we want to rebut the conclusive proof under section 112 of Indian Evidence Act? To rebut that conclusive proof, there is only one thing which the parties can prove, and that is non-access to the parties. Where will you find this provision? This you will find under section number 112 of Indian Evidence Act. ठीक है? I am telling you all the sections relevant to the questions alongside so that it is automatically covered for you, because CUET PG has a tendency of asking section numbers also. Similarly, IIT Kharagpur LLM वाले exams में concepts are also important and section numbers are also important. तो इसीलिए हम दोनों को साथ में लेके यहाँ पर चल रहे हैं. ठीक? चलो. Done. This is question number 9, which is not a precondition to raise an obligatory presumption under section 113B of Evidence Act. If we have to raise a presumption under section 113B of Indian Evidence Act, what things we need to prove? First, A, the accused is being tried for the offence under section 4 of the Dowry Prohibition Act. B, the deceased woman was subjected to cruelty or harassment by her husband or his relatives. C, such cruelty or harassment was for or in connection with the demand for dowry. D, such cruelty or harassment was soon before her death. So these three needs to be proved. B, C and D. इन तीनों को तो आपको prove करना ही पड़ता है when we talk about presumption of dowry death under section 113B. But you don't need to prove that any case has been filed under section 4 of Dowry Prohibition Act. ये कहीं पर भी नहीं दिया हुआ है. So this is your answer over here. All right. Where is dowry defined? 113B का presumption लगाने के लिए when we talk about definition of dowry. So there we take definition of dowry from section number 2 of Dowry Prohibition Act. And when was 113B inserted in Indian Evidence Act? So 113B was inserted in Indian Evidence Act in the year 1976, and this talks about presumption of dowry death, presumption as to dowry death of a woman. उससे related section है आपका section number 113B. ठीक है. A confession made in the police custody is admissible under section 26 of the Indian Evidence Act. A, if it is made in the presence of the doctor. B, if it is made in the presence of the captain of the vessel. C, if it is made in the presence of the magistrate. तो अगर पुलिस कस्टडी में कोई confession दिया जा रहा है तो वो कब relevant होता है? Your answer here will be option number C, if it is made in the presence of the magistrate. This is again a question from section number 26 of your Indian Evidence Act. ठीक है? चलो. Which one of the following is not correct about the expert opinion? A, the opinion of expert is seldom conclusive. B, facts which are irrelevant become relevant when they support the opinion of the expert. C, expert opinion is binding on the judge always. D, expert opinion is a suggestive piece of evidence. तो इसमें से क्या है जो सही नहीं है? Always at the time of solving your paper, you should read the question very carefully कि क्या पूछा गया है question में. Wherever not is written, pay special attention to this word not. ठीक है, not पर हमेशा special ध्यान देना चाहिए. Otherwise हम गलत answers mark कर देते हैं. So your answer here will be C, that expert opinion is binding on the judge. Expert opinion is not binding on the judge. But yes, expert opinion is rarely conclusive or is seldom conclusive. Expert opinion, when it corroborates with a matter which was earlier irrelevant, then it may make a particular matter relevant, and expert opinion suggests a piece of evidence. Yes, it is a piece of evidence. All right. Where is expert opinion defined? This can also be a question. So where it is defined? It is defined under section number 45 of Indian Evidence Act. ठीक है? Sure. All right, question number 12. The court cannot take judicial notice of which of the following facts? A, any news item published in the newspaper. B, any existence of title recognized by the government of India. C, the territories under the dominion of the government of India. D, the rule of the road and land or at sea. तो किस चीज का Judiciary does not take judicial notice of which fact, courts will not take judicial notice of which fact, court does not take judicial notice of the fact which is published in a newspaper. A newspaper cannot be presented before the court as a piece of evidence. It is not a relevant piece of evidence. उसका कुछ बहुत ज्यादा evidentiary value नहीं होता है. But yes, all of these are recognized by the court under section 57 of Indian Evidence Act. ठीक है, सेक्शन नंबर 57 पर आपके जुडिशियली नोटिसेबल फैक्ट्स वहां पर आपको मिल जाएंगे. ठीक, चलो आगे. राइट. Question number 13. In relation to the expression defined in section 3 of the Indian Evidence Act, which of the following statement is not correct? So फिर से हम fact की definition पे आ गए हैं, which is given under section 3 of the act. Fact includes A. Fact includes only physical facts, but also psychological facts. B. Quote includes arbitrators. C. An inscription on a stone is a document. D. A fact is said to be proved when it is neither proved nor disproved. ठीक है. Here also they have asked not. What is not correct? What is not correct? So your option number B is not correct. Court does not include arbitrator under the definition of Indian Evidence Act. But facts, yes, include physical facts and psychological facts. Not proved की definition भी यही है जो यहाँ दी हुई है. And ये document के illustration में दिया हुआ है. जो आपकी document की definition है, उसके illustration में you will find this illustration that an inscription on a stone is a document. ठीक. हाँ. The case of Savaldas versus State of Bihar is related to A. Plea of alibi, B. Rule of res geste, C. Rule of estoppel, and D. Rule of res judicata. So the case of Savaldas versus State of Bihar is associated with rule of res geste, and it is a very famous case related to Section 6 of Indian Evidence Act. The concept of Section 6 of Indian Evidence Act in India was adopted through this case, Savaldas versus State of Bihar, और बहुत अच्छे से it was explained that what is the concept of Section 6 under this act. कि res geste क्या होता है उसको बहुत अच्छे से यहाँ पर explain किया गया था. ठीक है. A is tried for the murder of B by poison. The fact that before the death of B, A procured poison similar to that which was administered to B is relevant, not relevant, partly relevant, neither relevant nor irrelevant. So poison है and he has the fact that before the death of B, A procured poison similar to that. This will be relevant. This will be relevant under section number 7 of Indian Evidence Act, which talks about the occasion, cause और effect. ठीक है. Occasion, cause और effect की जहां पर बात है वहां आपका ये वाला provision relevant होगा. ठीक है. The stipulation that facts which enable the court to determine the number of damages are relevant is incorporated under which section of Indian Evidence Act? Section number 12, 10, 8 or 11. So it is incorporated under section number 12. ठीक है. Section number 10 क्या बात करता है? This deals with conspiracy. Section number 8 जो है आपका ये बात करता है motive, previous conduct and subsequent conduct. Section number 11 talks about facts not otherwise relevant when become relevant. तो जो आपका plea of alibi वगैरह है वो section number 11 में जाता है. ठीक है. Section number 12 talks about damages, when for damages evidence is taken. ठीक है. चलो. All right. Question number 17. Propositions under Indian Evidence Act are 1. Statement is a genus, admission is a species, and confession is a subspecies. Second, statement and admissions are species and confession is a subspecies. Third, statement and admissions are gene and confession is a species. So which out of these is correct? I think only first one is correct, that statement is a gene and your confession and admissions are your, and then one second, statement is a gene and then admission is a species, and under admission we have confessions. So admission is always a species. Admission, अगर हम सिर्फ admission और confession की बात करते हैं, then admission becomes the gene and confession becomes the species. बट यहाँ पर जब हम तीन चीजों की बात कर रहे हैं तो स्टेटमेंट विल बिकम द जीन एंड एडमिशन विल बिकम स्पीशी एंड कन्फेशन विल बिकम सब स्पीशी. ठीक है, that is why your option number 1 is the correct answer, which is A. 1 is correct, 2 and 3 are incorrect. ठीक है, 1 second, right. Chal. Under Section 27 of Evidence Act, in respect of confessional evidence, first, so much of the information as it relates directly to the fact discovered in consequence of information received from the person accused may be proved against him. Second, person giving such information must be accused of an offense. Third, accused need not be in police custody. Four, any statement of the accused confessing his guilt must be made in the presence of a magistrate in all cases, whether anything is discovered or not in consequences of such statement may be proved against him. So out of this, which one is true? इसमें से कौन सा सही है ये बताना है आपको. So this is not true. A statement under section 27 can be made in police custody without the presence of a magistrate also. And if anything is discovered in furtherance of such statement, then it is relevant. तो ये तो गलत है. Accused need not be in police custody, ये भी गलत है. Accused needs to be in police custody for attracting section 27 का provision. Person giving such information must be accused of an offense. ठीक है, this is correct. And first क्या है? So much of the information as it relates distinctly to the fact discovered in consequence of information received from the person accused may be proved against him. So this is also correct. So 1 and 2 are correct. So your answer will be option number A. ठीक. Moving ahead. ठीक है. हाँ, the best evidence rule in relation to a documentary evidence is incorporated in which section? Section number 61, 62, 63, 64 and 65. ठीक है, किस में है best evidence rule? That primary evidence is the best evidence. ये कहाँ पर दिया हुआ है? This is provided under section number 64 of Indian Evidence Act. ठीक है, 65 में there is a method provided that for which under which situations you can produce a secondary evidence. ठीक है, secondary evidence कहाँ कहाँ produce किया जा सकता है? That is provided in 65. 61 gives the definition of primary evidence. Primary evidence क्या है? उसकी definition section 61 में है और section 62 में definition है secondary evidence की. 64 बोलता है कि primary evidence is the best evidence और 65 बताता है कि आप कैसे प्रोड्यूस कर सकते हो या फिर अंडर व्हाट सिचुएशंस secondary evidence can be produced. ठीक है, ठीक है. Under which section of Indian Evidence Act provisions for presumption as to gazettes in electronic form is provided? Presumption as to gazette in electronic form. I know that a lot of people do not read these sections, but it would be nice if you just know the section numbers and name of the sections. उतना भी sufficient है for this part of Indian Evidence Act. Option number A, section 85C, B, 81A, C, 88A, and D is section number 90A. So your answer here is section number 81A. I have been teaching for a long time now. Please like this video, share it, and if you're new to the channel, please subscribe to the channel. ठीक है, moving ahead. Question number 21. For the presumption of death under section 108 of the Indian Evidence Act, the person is shown to be heard for a period of how many years? A, 3 years, B, 7, C, 12, D, 30 years. यहाँ पर there can be a confusion between section number 108 and section number 107. दोनों बात करते हैं presumption of life and presumption of death से associated हैं दोनों ही sections. दोनों में terms provided है, so do not get confused. Under section 108, your term is of 7 years. And under section number 107, your term is of 30 years. ठीक है, तो यहाँ पर आपका आंसर है option number B, which is 7 years. ठीक? All right. Entries in a book of account are relevant. A, when they refer to a matter into which the court has to inquire. B, are relevant alone as sufficient evidence to charge any person with liability. C, are never relevant. D, none of the above. Evidence in books of account are relevant when it refers to a matter into which the court has to inquire. This is very simple. जब court के पास जाएगा तो ही उस पे question raise होगा, otherwise it is not relevant. ठीक है? ठीक है, हाँ, and provided under section number 34 of Indian Evidence Act. Although this section you do not need to remember, it's not a very important section number. ठीक है. Uh, for conclusive proof of legitimacy under Section 112 of the Indian Evidence Act, the person must be born during the continuance of a valid marriage between his mother and any man, or within how many days? Within how many days should the child be born to be known as the uh, child of the father? A 290 days, B 280 days, C 300 days, and D is 270 days. The answer here is 280 days. Section number 112 specifically provides this period for creation of conclusive proof or for creating this presumption. ठीक है. Question number 24. Which of the following is not true with respect to dying declaration? You should know where dying declaration is provided. What is dying declaration? You should know that. You should know the essentials of a dying declaration and what is the very important maxim associated with dying declaration. So first, 8 is based on the maxim nemo morituis prosumitur mentiri. B, it must pertain to the cause or circumstances pertaining to his death. C, it must be recorded by a judicial magistrate. D, it must be made voluntarily. ठीक है. So here, dying declaration is provided under section number 32, subsection 1 of Indian Evidence Act. ठीक है. All of the options are correct. The maxim nemo morituis is पे ही based है your principle of dying declaration. It means that the person who is dying will not lie, will not die with a lie in his mouth. ठीक है. So this is correct. It must pertain to cause or circumstances pertaining to his death. This is also correct. It must be recorded by a judicial magistrate. ये गलत है. It can be recorded by any person at all. So this is your answer over here. Must be made voluntarily. Yes, it should be made voluntarily. ठीक है. All right. Res geste is allowed as an exception to. Res geste is an exception to what? Option number A, confession. B, dying declaration. C, hearsay evidence. D, documentary evidence. सबसे पहले where is res geste का principle? अभी we studied the case of Savaldas. That was an important case related to res geste. Where is res geste provided? Res geste is your section number 6 of Indian Evidence Act. It is what? It is an exception to the rule of hearsay evidence. आपका answer यहाँ पर है ये. And confession and dying declaration are also an exception to hearsay evidence. ठीक है. तो ये तीनों ही चीजें आपके hearsay evidences का exception होती हैं. हाँ, a confession even consists of conversation to oneself, for it is not necessary for the relevancy of a confession that it should be communicated to some other person, was held in the case of A, Shankara versus State of Rajasthan, B, Bhuta Singh versus State of Punjab, C, Sabu versus State of UP, D, Nishikant Jha versus State of Bihar. So the answer here is Sabu versus State of UP. Sabu versus State of UP से the concept of soliloquy confession came out, that a person, even when he is speaking to himself and no one is around, and if someone has heard him from the outside, this also amounts to confession. Speaking to yourself also amounts to a confession. Was held in Sabu versus State of UP. The concept of soliloquy, a confessional soliloquy is a direct piece of evidence. ये जो concept था ये आपके साहू वर्सेस स्टेट ऑफ यूपी के केस से आया था. ठीक है. Which of the following sections of Indian Evidence Act deals with conclusive proof? Conclusive proof कहाँ पर provided है under Indian Evidence Act? Also, where is conclusive proof defined? So conclusive proof is defined under section number 4 of Indian Evidence Act. A section 41, B 112, C 113, या all of the above. So your answer here is all of the above, क्योंकि 41, 112, 113 तीनों ही conclusive proof की बात करते हैं. ठीक. 41 is about judgment in rem related to probate, admiralty, etc. jurisdiction. 112, birth of a child. And 113 is about cession of territory. ठीक है. Which of the following is not correctly matched? A, confession by inducement, threat or promise when irrelevant in the criminal proceeding, section 24. इस टाइप के क्वेश्चंस बहुत आते हैं आपके एग्जाम्स में, सो बी माइंडफुल ऑफ सच क्वेश्चंस. बी confession made after removal of impression caused by inducement, threat or promise relevant. Section 28. C confession otherwise not to become irrelevant because of promise of secrecy, etc. Section 29. तो इसमें से क्या कोई गलत है? Is anything over here not correct? All of these are correct. So your answer is D, none of the above. ठीक. Which special provision regarding proving of records have been inserted by the Indian Evidence Act by IT Act 2000? So for proving electronic records, which sections were introduced by IT Act? Section number 65A and 65B, section number 56A and 56B, section 55A, 55B, 35A, 35B. What is the answer? I actually said the answer at the very beginning. So your answer is section 65A and 65B को introduce किया गया था after Information Technology Act 2000 came into force for proving of electronic documents and electronic records. All right. Moving to your another question, which one of the following is not an exception to the doctrine of estoppel under Indian Evidence Act 1872? A, when the truth is not an exception. When the truth is known to both the parties on the question of law, on the question of fact, against the law. इसमें से क्या है which is not an exception? On the question of what is an exception here? अरे 1 second. If it is made on a question of fact, then it is a doctrine of estoppel. If any false statement is said when both the parties know that it is the truth, तो फिर तो estoppel होगा ही नहीं. अगर दोनों को ही पता है कि सच है तो estoppel कहाँ से होगा? Question of law पे अगर है तो law को लेके आप झूठ बोलो चाहे नहीं बोलो, there is always a presumption that everyone knows the law. ठीक है, so यहाँ पर भी नहीं हो सकता. Against the law, it cannot be against the law because you should know that what is the law. तो अगर आपसे कोई आगे झूठा लॉ बता रहा है तो वहां पर एस्टॉपल का प्रिंसिपल अप्लाई नहीं होता. बट yes, if someone is telling you a fact which is false, then doctrine of estoppel will attract. ठीक, चलो. Under Indian Evidence Act 1872, leading questions may be generally asked where? A, in cross-examination, B, in examination in chief, C, in re-examination, D, none of the above. Where are leading questions provided? This also you should know. So leading questions are provided under section number 141 of Indian Evidence Act, and they may be asked in cross-examination. Option number A is your correct answer. Okay. Consider the following statements and choose the correct answer. The law of evidence may be defined as a system of rules for ascertaining controverted questions of fact in judicial inquiries. Second, the act applies to all judicial proceedings in or before any court, including court-martial, but not to affidavits presented to any court or officer, or to proceedings before an arbitrator. So what is correct here? Which statement is true and which statement is not true? Both the statements are true because under Indian Evidence Act, it provides a system of rules for judicial inquiries कि evidence कैसे लिया जाएगा यही बताया जाता है Indian Evidence Act में. और दूसरी चीज ये अप्लाई करता है सब पर एक्सेप्ट आर्बिट्रेटर्स एंड एफिडेविट्स. ठीक है, तो 2 इज ऑल्सो करेक्ट. और कोर्ट मार्शल्स पे अप्लाई होता है, बट कौन से कोर्ट मार्शल्स पे नहीं होता? आर्मी एक्ट के अंदर, एयरफोर्स एक्ट के अंदर एंड नेवी एक्ट के अंदर जो कोर्ट मार्शल अपॉइंटेड हैं उन पर एप्लीकेबल नहीं है. अदर देन दैट एप्लीकेबल ऑन everyone, every court proceeding. All right. ठीक है, consider the following statements. Now, assertion reasoning based questions भी आप लोगों के एग्जाम्स में बहुत आते हैं. So you need to be mindful of those type of questions also. Consider the following statements and choose the correct answer. When the document is a registered one and its execution is not specifically denied, the attesting witness need not be called. Second, when the execution of a will is admitted, the attesting witness need not be examined. What is correct over here? तो जो आपका first statement है, when the document is registered और उसका execution is not denied, तो attesting witness को बुलाने की जरूरत नहीं होती है. So statement number 1 is correct. जब execution of a will when is admitted, तो attesting witness need not be examined. Need not be examined ये सही नहीं है. A testing witness is not needed is correct. But if there is an attesting witness and examination is needed, then examination can be done. So only your statement number 1 is true, which is option number C. Let's see the answer also. Yes, option number C. ठीक है. Section number 68. All right. As per Indian Evidence Act 1872, a party to a suit can prove a fact in issue A by examining one witness only in proof thereof, B by examining any number of witnesses in proof thereof unless the court is satisfied that examination of any particular witness is not relevant and is with the intent to delay the trial, C by examining not more than 3 witnesses, D by examining any number of witnesses in proof thereof, and the court cannot limit the number of witnesses sought to be examined. So this question basically pertains to how many witnesses are needed for examination. Kitne witnesses chahiye, and can the court limit the number of witnesses? So this is related to your section number 134 of Indian Evidence Act, which provides that there is no limit to the number of witnesses. No proper number of witnesses are necessary for proving any particular thing. But if the court is of the opinion that any particular witness need not be examined, or usko examine karne se it will lead to waste of the time of the court, then court will not examine such witness. So your option number B over here is your correct answer. ठीक है? Right. Moving to the last question for today. This will be the last question for today. I know this is only 35 questions, but I have tried to cover your Indian Evidence Act entirely in this 35 questions. Jahan se I thought and I picked up the questions. So we have tried to cover it in that manner. A quick revision, so I hope आप लोगों का हो ही गया होगा. Question number 35. A retracted confession A can be made solely on the basis of conviction. B cannot be made solely the basis of conviction under any circumstances. C cannot be made solely the basis of conviction unless the same is corroborated. D, both A and C are incorrect. ठीक है. What can happen? What is a retracted confession? So first of all, you should know that what is a retracted confession. A retracted confession is when originally a person has given a statement and later on the person denies that confession or goes against that confession. तो क्या ऐसे confession को हम use कर सकते हैं? Can that be made a sole basis for? Can that be made a sole basis for conviction? So it cannot be made a sole basis for conviction until and unless it is corroborated. Until and unless it is corroborated. So option number C is the correct answer. ठीक है. This is it from my side, guys. If you want to join any batches with us relating to LLM entrance exams or related with your law officer exams, you can go to toprankers.com. You can go to online courses here on Law PG plus banking. You can click over here. You can select any of these and you can explore our courses for a more better and detailed guidance to your preparation. This is it from my side, guys. Take care. All the best for your preparations. Prepare well. All the best for your exams. Happy learning. Bye-bye.